Now, how many recordings are you planning to actually attempt to play for the jury, Ms. Kappelman?
I believe there's 45.
That you plan to present?
Yes, sir.
And who do you plan to present those through?
Through Agent Sanford.
Does anybody have any different argument between 175 and 179? It seems to be the same issue as to both. Anybody have any different argument as to those?
Just 1 second, Ron.
On behalf of Ms. McBride, I'm resting on the previous objections and arguments.
The same for Mr. Garcia.
Yeah. Do you have any different argument, Ms. Kappelman?
No, sir.
Well, by my assessment, what's really been done is that the state is attempting to present a summary of testimony which is allowed under 90.956 Florida statutes. The problem is they've not given timely written notice of that, which is what the statute requires. The statute does allow parties where you have voluminous writings or records or recordings, and they specifically relate to recordings, to present a summary without presenting the underlying materials. It does not prohibit the underlying materials being presented, which sounds like what the state intends to do. The purpose of the timely written notice, according to Professor Earhart, is to give the opposing party time to inspect the underlying records, which has occurred in this instance, and to confirm that the summary is accurate, which, since it's not been noticed, they've not been given that opportunity. However, both witnesses have been subject to cross-examination on this testimony. Mr. Rivera is still on the witness stand, so we haven't even gotten to the cross-examination on this subject by the defense. They still have that opportunity to cross-examine on that subject. But the state has not complied with their notice requirements. I'm going to sustain the objection to 175 and 179, but I am going to allow testimony as to which tapes were identified by the two witnesses that listened to them. However, I'm not going to let 175 and 179 go to the jury. My thinking is that both witnesses have been subject to cross-examination on the subjects. Therefore, their identification of it is admissible. So that would be my ruling as to 175 and 179. The other issue we had related to the Collins, I don't see either of the Collins present here.
No, sir, I've released the Collinses.
You're not going to call them as
Yes,
witnesses?
Sir.
All right, so that's a non-issue. Any other issues we need to take up?
Judge, I would like to address a couple issues. I would like to renew my motion in limine regarding Mr. Rivera's gang status in light of the cross-examination that's occurred thus far, and move to amend the motion to include prior bad acts. We've heard several specific instances of prior bad conduct on the part of Mr. Rivera, including drug dealing and robbery, that are irrelevant to the case that we're here about today. I guess I'm just moving to exclude any additional testimony at this point regarding Mr. Rivera's prior bad acts as more prejudicial than probative, irrelevant to the case before the court and improper character evidence. Do you want to hear my other one, or do you want to address that one first?
What's that?
I have another matter as well. Do you want to move on, or?
No, we'll deal with that first.
Okay.
It's not crystal clear what you're asking me to exclude, Ms. Kappelman.
Any prior incidences of specific prior bad acts by Mr. Rivera, to include but not exclusive to prior robberies that have nothing to do with this case, prior drug dealing that has nothing to do with this case, or any other criminal acts unrelated to this case.
The problem is your objection is about as generic as Mr. Sanguinet's questions, neither of which allow me to really focus on what I think is admissible and inadmissible. I've said that anything related to Mr. Rivera's acts that encompass the federal prosecution, which essentially is part of the plea agreement in the case, because he's getting a concurrent sentence to run with that, is fair game. I waited for objections yesterday without receiving them as to generalized questions about anything Mr. Rivera has ever done wrong in his life, which clearly is inadmissible. But neither of you have helped me much in making that separation. I'm going to have to deal with it instance by instance, so the state, if they want to be heard, needs to make a timely objection when the question comes up. I'm not going to try to generically rule on it. I've told you, and I said from the start, which neither of you paid much attention to, that what he did as part of the federal prosecution is admissible. His gang status is admissible because that was part of the plea bargain. But I would agree that everything that Mr. Rivera has done wrong in his life is not admissible, which many of the questions yesterday seem to elicit. So that's been my consistent ruling. I'm not going to try to parse it out here with a generic objection. I will sustain objections to generic questions that ask what Mr. Rivera has done wrong in his life, which was essentially what many of the questions yesterday involved. You said you had another issue.
Judge, at this time, the state would renew its motion in limine in reference to Mr. Rivera's schizophrenia diagnosis. Rivera testified for several hours yesterday with no indication that he was suffering currently from any mental health symptoms. He was also able to recall the events associated with the crimes charged without any indication that he was suffering from any hallucinations or other mental health symptoms at the time that he made these observations. As such, the state requests the defense be precluded from asking about his diagnosis in the presence of the jury, as there is no basis to believe that his diagnosis was interfering with his ability to see and observe the events about which he is testifying. And asking him the question about the diagnosis would ring a bell that could not be reversed and would constitute nothing but improper character evidence in the absence of a nexus to this case.
I deny that motion. I think we've already parsed out that there are two times when the mental health may be relevant, would be at the time of the offense, and as he's testifying, the defense should limit themselves to questions that relate to at the time of the offense or now as he speaks. But beyond that limitation, his mental status is fair game as to those two times. Anything else?
Judge, at this time, the state requests that to address the procedure used to impeach Mr. Rivera in light of his literacy limitations per Section 614.1. Rivera has a right to be confronted with his alleged inconsistent statement or to have his recollection refreshed outside the presence of the jury. My suggestion in thinking through how this could work, since he can't read and this thing's going to have to be read to him, is to possibly have each counsel wait until the end of his or her examination, have the jury step out, whereby Mr. Rivera can have the opportunity to be read any and all statements that are going to be offered to refresh or impeach him, and then we can bring the jury back in to resume inquiry regarding those statements.
Well, the proper method of impeachment is, at least in terms of depositions, which was not followed yesterday, was to read verbatim the question and answer and ask the witness if he recalls that question and that answer. His literacy imposes no restrictions on that, and that's the proper way to do it anyway. I'm not going to send the jury out to refresh his recollection as to everything that's asked. I don't think that's feasible. So we're just not going to have any feasible way to refresh his recollection, since in most instances we do that by written document. Frankly, I don't know how to do that. If the defense has some suggestion, I'll hear from them. Mr. Sanguinet, do you have some position on how do you wish to refresh his recollection on issues?
So I think that we have, I think the easiest way to do it would be to have it read to him.
Well, the problem with that, you're not supposed to, you can use anything to refresh somebody's recollection, but the idea is that's not supposed to be presented to the jury, so we defeat the purpose of refreshing recollection. That's what the state says. They're correct. That's not something that should be presented to the jury, so you can't refresh recollection in the presence of the jury by reading something to him.
I meant outside the presence of the jury.
Well, but the logistical problem with that is how we're going to do that.
I assume it was in a case like this.
Well, we're not going to send the jury out each time you wish to refresh his recollection. That's not workable. Ms. Kawaz.
Yes, Your Honor. Depending on what Mr. Rivera decides to testify today, if I lay the proper predicate, I could, under Florida statute 90.803 subsection 5, try to enter it in as a past recorded recollection, since these are all prior, well, the ones that the state decided to record. If he attests to the authenticity and the accuracy at the time that it was taken, and he does not remember today, I can introduce it into evidence pursuant to the case.
I don't agree. That's what we're not going to put into evidence every statement he's made. In terms of prior recorded situations, you just need to ask him if that's what he previously said. That's not very complicated. We seem to make that very complicated, but he gave a statement on a date and time. Did you tell the investigator or the officer X, Y, and Z? It needs to be verbatim. If it's a recorded matter, either he'll acknowledge he said that, he'll say he didn't say that, or he doesn't recall. If he says he didn't say that or doesn't recall, then you're free in your case to present evidence of it. We don't argue with the witness about it, which is what occurred yesterday. I think anyway, as to the refresh and recollection, though, do you have an issue on that, Ms. Kawhi?
Your Honor, I just don't want to break the flow of the cross-examination, so if it, if it gets to a point where it's becoming uncomfortable or not, presentable to the jury, I don't know if we could take a sidebar or something and come up with something else.
Mr. Sanguinet, yes.
Yes, Judge, I just want to put the court on notice. I know that Mr. Rivera did testify yesterday that he's unable to read and write, but in Government's Exhibit 128, which has already been entered into evidence, which is Mr. Rivera's phone records, he sent between May of 2014 and October of 2014 over 8,000, sent and received over 8,000 text messages. Text messages are non-verbal communication. which would suggest that he was receiving nonverbal communication. Obviously, text messages have a slew of things that they do, but I would say the majority of it is actual writing. And he responded. I think he received 5,000 text messages and responded to, I think.
And your point is what, Mr. Sanganan?
My point is, I believe that his testimony in regards to his inability to read or write are not completely candid. And I also believe the evidence will show in 2016, Mr. Rivera entered and completed a reading and writing course in federal custody and received a passing grade.
Well, those seem like appropriate things for cross-examination, but I think as to the refreshing the recollection, what I'm going to do at the end of your cross-examination, if there's anything, and I guess we'll do it twice, we'll do it at the end of Garcia's cross-examination, we'll do it at the end of Magbanowa's cross-examination, and we'll do it at the end of the redirect. If there's anything you wish to refresh the recollection of the witness by, let me know that, and we'll send the jury out and give you a moment or however long it takes to read to the witness what it is you wish to attempt to refresh his recollection with, and then we'll recall the jury. Now, I'm not necessarily going to remember that. Y'all are going to have to remember that, but that's the only thing I can think of to do. We can't refresh the recollection in front of the jury, but we'll do it at those three stages. Anything else, Ms. Kaplan?
No, Your Honor. Oh, yes.
Yes, Judge, yesterday with Sergeant Corbett, I did some demonstratives. I printed copies and would like to make them just part of the court, part of the record, if that's okay.
All right. Show them as, how have you marked them?
I do court exhibit A and B.
All right, do court exhibit A and B. They're not to go to the jury. They're just for record purposes.
Yes, sir.
All right, if he has further demonstratives, let's make them part of the record in the same way.
Yes, sir.
Anything else from the state?
No, Your Honor.
Garcia? McBanowa?
Yes, Your Honor. With respect to the documents for Investigator Sergeant Corbett, if we can get a copy of it, we had asked for that yesterday from the state. We have no copies of those.
Provide them a copy of it, please, Ms. Norris.
Yes, sir.
Anything else?
No, Your Honor.
We'll start with the jury at 9 o'clock. Let's have the witness on the stand, please.
Thank you, Judge. Mr. Rivera, good morning.
Good morning.
I've got up here on the screen. Can you see that, sir?
Yes, sir.
I've got up on the screen phone records that have been entered into evidence as Government's Exhibit 128. There's a portion right here.
If he can read that, his eyes are a whole lot better than mine.
Sure.
You can't blow that up a little bit. I think there's a knob there. I've seen them used.
It's through the laptop.
Okay. All right.
The government asked you this on direct examination yesterday, and I just want to confirm that your phone number, or one of your two phone numbers, was 305-570-8153. You recall that, sir?
Yes, sir.
And what's already been entered into evidence is Government's Exhibit 128, are the specifics that AT&T has and that they document and they keep with regards to your phone activity, sir. Are you aware of that?
Yes, sir.
And your phone activity that's documented in this state's exhibit, it includes phone calls as well as text messages. Are you aware of that?
Yes, sir.
You indicated yesterday that you were unable to read and write. Is that correct?
Yes, sir.
From the month of May of 2014 till October of 2014 with phone number 305-570-8153. Were you aware that you participated in 7,885 text messages back and forth?
Yes, sir.
And you'll agree with me, a text message is a nonverbal communication?
You can talk to the phone and it'll spell it out for you.
And that's your testimony that that's what you did in every single text message?
Yes, sir. I had an iPhone.
And what about receiving text messages? They were also voicemails? That's your testimony?
Yeah, they read it out to you.
And you indicated also that you were attempting to get your GED, but we interrupted your education
Yes, sir.
in your testimony yesterday. In 2016, while in federal custody, did you take any classes with regards to reading and writing?
I've been doing that my whole life, though. I'll tell you that.
So you've been taking classes to read and write your whole life. Isn't it true that in 2016, while in federal custody, as part of the federal program, you received passing grades with regards to reading and writing courses?
I get help. I got a tutor.
So you didn't really answer my question. I see that you had a tutor, but the answer is yes, correct? You received passing grades
Yes, sir.
in reading and writing.
Yes, sir. I had a tutor.
And yesterday, when the government asked you to read a document, your testimony under oath was that you can't read and write, correct?
I can't.
So let's go back to what we were talking about yesterday with regards to your June 4th trip. And that's the trip that you took in a Nissan, I believe it was Sentra, correct?
I guess so.
Now, you didn't rent the Nissan, correct?
No, sir.
But in the July trip, you did rent the Toyota Prius, correct?
Yes, sir.
Okay. And it was your testimony yesterday that you rented it while Mr. Garcia was around the corner waiting for you outside of the rental place, correct?
Yes, sir.
Showing the jury.
Before you, why don't let the technician handle that instead of you switch to the Elmo type function?
Thank you, sir. All right, Mr. Rivera, you filled out this document alone while Mr. Garcia was around the corner, correct?
Yes, sir.
And you wrote your name right here
Yes, sir.
where it says renter's name.
Yes, sir.
You didn't write the name where the unit number is, correct?
What unit?
Right next to it, to the right, where it says unit number. You didn't mistakenly put your name where it says unit number. You put your name where it says name, correct?
Yes, sir.
All right, that's because you read the word name and you knew to write your name next to
No,
it.
I asked the guy where do I write my name and everything. He told me fill it out right here. Is what you put your name and your address.
So all this was at the assistance of somebody else, correct?
Yes, sir.
Mr. Rivera, can you read that?
It's my name.
What does it say?
Louis Rivera.
You can't read this whole thing?
My name, Louis Rivera.
Your name, so it says my name is Louis Rivera?
Yeah. It's like a third grade level.
Hold on. But it's your testimony now, but where it says renter's name right here, you needed assistance.
Yes, sir. At that time, I needed it. I'm taking classes now to learn how to read and write.
When you took your final exam in your GED level course in federal prison, was your tutor there with you when you passed?
Yes,
Did
sir.
he take your exam with you?
He was right next to me.
Government's Exhibit 83. It's going to be your testimony that the person that budgeted in also helped you fill out this form?
Yes, sir.
Couldn't do it on your own?
No, I can't.
And it's your testimony that you asked the person at the budget in to read the document so you could fill out exactly what he needed to
Yes,
fill
sir.
out.
I asked him.
I'm listening. On the June 4th trip, did you ever indicate that Sigfredo drove the whole way?
June 16th?
The June 4th trip, have you ever previously said that the person that was driving the entire trip was Sigfredo Garcia?
He rode halfway and I rode the other half.
Have you ever indicated in previous statements that he was the only person that drove?
Yes, sir.
Okay. And today was the first time when the prosecution showed you that you actually got the ticket, that your testimony was that you drove the second half, correct?
Yes, sir.
Okay. And isn't it also true that in other statements that you've given, you indicated that you received the ticket on the July 14th trip, correct?
Yes, sir.
So let's talk about June 4th. Had you previously testified that you arrived in Tallahassee in the early morning time?
Yes.
All right. And your previous testimony had been that you'd arrived around 9 or 10 in the morning, correct? Maybe earlier?
Yeah, I said that.
Okay. And that your previous testimony was that when you got there that you kept partying, right, for a little bit?
Yes, sir.
Okay. And then you guys went to sleep for about an hour before you headed out, correct?
I don't remember that. I said an hour?
But you
don't
went
remember.
to sleep for a little bit, correct?
Probably.
So, arrived in Tallahassee in the early morning hours, kept drinking and doing cocaine, and then slept for a little bit before you left to go to Mr. Markel's house, correct?
Yes, sir.
And you'll agree with me that when the government showed you your travel citation in Gainesville, about 250 miles away, multiple hours away at 9
How
a.m.
far
in the
away, Mr. Zangada?
I'm sorry?
How far away?
About
Let's
200
not mislead the witness, please. That's
Well,
not accurate.
Okay. From Gainesville to Tallahassee, right? It's quite a drive, correct?
Yes, sir.
More than 100 miles, if you recall?
I don't know, sir.
So, between Gainesville and Tallahassee, multiple hours, and the citation's at 9:12 a.m., correct?
Yes, sir.
And your testimony changed and your timeline changed yesterday when the prosecution showed you the ticket. Is that correct?
I don't know about my time change, but
Your timeline,
my timeline?
yes. Because you'll agree with me beforehand, you said that you got here in the early morning time, correct?
Yes, sir.
All right. Now, you received the citation at 9:12, and Gainesville's at least 100 miles, as you indicated. It's quite a drive from Gainesville to Tallahassee,
I
you'll
guess
agree,
so.
correct? Right. So you'll agree with me that you did not arrive in the early morning time. You were in Gainesville in the early morning time, right?
Yes, sir.
You also indicated on direct examination that Mr. Garcia never used any kind of navigation technology on his phone, correct?
Yes, sir.
All right, so it's your testimony that you got to and it's also been your testimony that you've never come to Tallahassee before, correct?
Never been to Tallahassee.
And that Mr. Garcia at no point utilized any kind of electronic media to help him get around in Tallahassee, right?
He never used any electronic, but we did stop in the store.
And you got a map.
Yes, sir.
And you said that he looked at it once and didn't look at it again, correct?
Yes, sir.
All right. So your testimony is that Mr. Garcia looked at a map once and never looked at it again.
Yes, sir.
Is Tallahassee like Miami in terms of how the streets are, like avenues and streets, like numbers and like how you can go? I'm going up from 88th Street to 157th Street. They don't have that here, do they?
I don't think so.
And you also testified that you purchased a gun, right?
Yes, sir.
And that you purchased bullets, correct?
Yes,
Mr.
sir.
Shangaday, we're not gonna repeat everything you did yesterday. I think we did it 2 or 3 times yesterday. That's enough. Move on.
When you get to the hotel room, the first time, you said that you had somebody purchase the room for you, correct?
Yes, sir.
All right. And the reason why you would do that was because you wanted to potentially hide, you didn't want to leave any kind of footprint that you were in Tallahassee, right?
Yes, sir.
Is that correct?
Yes, sir.
And that's because, according to your testimony, your best friend tells you several hours into a trip that it's not a robbery, it's a homicide.
Yes, sir.
Would you consider that misleading?
What you mean by misleading?
Right. So your testimony has been, and you've proffered to this jury, that he's somebody that you've grown up with and he's one of your best friends, right?
Yes, sir.
Okay. So you'll agree with me that your testimony in court is that he didn't tell you the purpose of the trip, right?
He didn't tell me at the beginning.
Right. Well, that's what I'm talking about. To get you to go on the trip, he didn't tell you the purpose of it, right?
Yes, sir.
Okay. But he did offer you money.
Yes, he did.
And it was your testimony yesterday that the second day that you were there, you didn't feel like going forward with the murder, correct?
Repeat that question again, please.
No problem. It was your testimony yesterday that I believe you said because you're not going to kill somebody just because he has kids and that you don't know the man. Something like that, but you recall saying that, right?
Yes.
Okay. And based on that statement that you guys called off the purpose of your trip and left Tallahassee, correct?
Yes, sir.
Okay. And it's your testimony that you were the driving force behind calling this off and leaving Tallahassee?
Well, it was nothing to do. There was nothing to be around there for, so we left.
Okay, so let me ask a few questions about that. You indicated that Mr. Garcia had been paid and you saw cash in his pocket, correct?
Yes, sir.
And you said it was between $2,000 and $5,000, right?
Yes, sir.
And you got there on June 4th in the morning, right?
Yes, sir.
And between June 4th in the morning and what time did you guys leave on the 5th?
I don't remember the time.
Roughly. Was
I don't
it
remember
nighttime?
the time, sir.
Was it nighttime?
I don't remember the time.
Okay. Do you remember if it was light or dark outside?
I can't remember.
Whose idea was it to leave?
Both of us.
According to you, had Mr. Garcia run through all the money that he'd bought?
Yeah, we was low on cash.
Okay. And you also said that he'd given you some money from his pocket, correct?
Yes, sir.
You'd also said that you had bought your own a substantial amount of narcotics during the trip, correct?
Yes, sir.
And you also said that Mr. Garcia had purchased additional narcotics, correct?
Yes, sir.
How much money would you say that he had spent on narcotics?
Ain't no telling right now. It's been a long time.
Okay, well,
can't remember.
I'm sorry. I didn't mean to interrupt you. Mr. Rivera, can you guesstimate?
I said ain't no telling. I can't remember how much money we spent, but we spent money.
Okay. Well, What's your definition of money on cocaine?
About $200.
Okay. So, as someone that has experience in the drug trade, right?
Yes.
$200 or $300 would be maybe another 8 ball, right?
Maybe like 2 or 3.
2 or 3 more 8 balls. So you're at about 15 grams of cocaine for a 36-hour trip, according to you, right?
Probably.
So $200 to $300 on drugs. How much was the room? $100?
Yeah, I don't remember.
Okay. Does that sound about right? Let's be very generous. Let's say $100.
I can't tell you, I don't remember.
All right. It was a motel though, right? It wasn't the W or a 5-star hotel.
There's a hotel. It can be one night for $60. For 2 nights, it can be 120.
And you guys
It
stayed there
depends.
one night, right? June 4th. And you left June 5th, right?
Yeah, I think so.
Okay. So one night at a hotel, let's say between $50 and $100. Sound about right?
Yeah.
Okay. And you guys ate at Hooters, right?
Yes, sir.
Ate and drank at Hooters. You didn't want to be seen, correct?
Yes, sir.
Yet you went to a known restaurant, right?
Yes, sir.
And you said that you guys were there for multiple hours, correct?
Yes, sir.
Were you wearing a hat?
Yes, sir.
You were wearing a hat?
Yes, sir.
Were you wearing sunglasses?
I don't remember.
You didn't have the mask on at Hooters, did you?
No.
No, right? Okay. So you're in public, being seen in Tallahassee for multiple hours, correct?
Yes, sir.
Okay. You and Mr. Garcia have purchased and consumed, according to you, multiple ounces, multiple grams of cocaine, correct?
Yes, sir.
And you're, I assume, drinking substantially at this point, correct?
Yes.
After you leave Hooters, where do you go? Back to the room?
Yeah.
Now, what time in the morning do you leave to start your surveillance the next day?
That Friday?
I'm sorry?
And then the murder day?
No. We're talking about the June trip today, sir.
All right.
What time do you leave?
In the morning,
Yes, sir? What time? Do you remember?
like 7 or 8 around there.
Had you checked out of the hotel when you left in the morning?
I don't remember.
Did you remember, checkout's usually around 11 a.m., right?
Yes, sir.
Okay. So that morning, you'll agree with me that you hadn't decided whether or not anything was going to happen that day, right? Your plan was you were going to go kill Dan Markel that day, correct?
Yes, sir.
Okay. So you'd planned to go commit this murder, and you weren't sure whether or not it was going to happen, correct?
Yes, sir.
All right. So did you check out of the hotel, or did you keep the hotel for another day?
I can't remember if we checked out or not. I cannot remember.
Okay. So then you drive over to Mr. Markel's house, correct?
Yes, sir.
To the area, and you conducted surveillance, right?
Yes, sir.
And then you followed him to the daycare center, correct?
Yes, sir.
All right. And then you lost him, right?
Yes.
Did you conduct any additional surveillance that day, or did you call it quits?
I don't know if we were in the, okay, I can't remember.
you indicated to the jury on direct examination that it appeared that on that second day that you felt that this was the wrong thing to do and you didn't want to be involved in killing somebody that you didn't know, correct?
Yes, sir.
And you'll also agree with me that you realized that Mr. Garcia, according to your testimony, wanted you to be the shooter in this case, correct?
Yes, sir.
And as a result of that, you were going to be paid $35,000, correct?
Yes, sir.
Now, you were actually paid $37,000, correct?
Yes, sir.
So you were paid more than you were originally told, right?
Yes, sir.
And as we indicated yesterday, your testimony is that you didn't do the job that you were hired to do. You simply were, in essence, like a chauffeur, correct?
Yes, sir.
Are you on any medication right now?
No, sir.
None?
Not at all.
Were you on any prescribed medication at the time of the June or the July trip?
No, sir.
Give me 1 second, Dave.
You mind?
Have you ever been diagnosed as being bipolar?
Yes, sir.
What about schizophrenic?
Yes, sir.
On the June 5th surveillance that you conducted of Dan Markel, when you said he went to the daycare, did you see him drop the kids off at the daycare?
Yes, sir.
And so he was alone at that time, correct? Because you saw him drop off the kids?
Yes, sir.
Now, you indicated that after you called off the purpose of your trip, you drove back to Miami, correct?
Yes, sir.
And it's been your testimony that from June 5th, because that's when you got back to Miami, right? June 5th, the next day,
Yes, sir.
the next night. June 5th, that there was no communication or no discussion with you and Mr. Garcia about anything else until, I believe, the 14th of July?
Yes, sir.
Would it be a fair statement to make that you made it clear, according to your testimony, that you did not want to participate in this job to Mr. Garcia, correct?
Yes, sir.
And then during your direct examination, actually, you kind of went to substantial detail to tell the members of the jury how you felt that this was an inappropriate thing to do, correct?
Yes, sir.
Right. Yet, when Mr. Garcia, according to your testimony, calls you, you go rent a car immediately, right?
Yes, sir.
You didn't tell him, "Oh man, don't you remember what I told you June 5th? I don't want to be down with this," right? You didn't say that, did you?
No, that's my best friend.
Okay, well, but he was also your best friend on June 5th, right?
Until I'm dead, I'm gone, I guess.
Right, so he was your best friend on June 5th as well, the same day that you said, "No, I don't want to do this," and in essence, you guys left, right?
Yes, sir.
5 weeks later, he tells you, "Let's ride," and you immediately go and rent a car in your name, yes?
Yes, sir, I did.
How many guns did you take the second time up?
One.
One, correct?
Talk about for the murder?
Yes, sir? For- when
I
you
just want to
committed
make
murder.
sure where we at.
I'm sorry?
I just want to make sure where we at.
So, you'll agree with me that on the trip, on the June trip, you were extremely cautious about not leaving any kind of fingerprint, okay, or any kind of trace that you were in Tallahassee, right?
Yes, sir.
Okay. Yet on this second trip, you rented a car, right?
Yes, sir.
And whose name did you rent the car in?
My name.
Whose hotel did you rent the hotel room in?
It says my name on it, right?
Were you taking your medication on that day? No, you weren't, right? You weren't
No.
taking any medication that
Not
day?
at all. Just cocaine.
So you consider cocaine to be medication?
It's medication.
Have you been taking cocaine for medication for a long time?
I've been doing cocaine since the age of 15 years old, sir.
And how old are you now?
36.
Would you say that you do cocaine on a daily basis, or did cocaine on a daily basis?
Not once in a blue. Not like that. Not every day.
When you say once in a blue, what does that mean?
Maybe on a weekend. Maybe in a party.
So 50 times, let's just be conservative. Once a week there's 52 weeks in a year, correct?
Yes.
Right?
I
mean,
guess.
that's not a trick question. There's 52 weeks in a year. You're aware of that, correct?
Yes, sir.
Okay. And you're saying that you did cocaine once a week, so that's 50 times a year, right?
Yes, sir.
For 20 years?
Yeah, I'm 36.
Okay. So about 1,000 times?
Maybe, yeah.
Now, have you ever testified that you believe, well, who do you believe convinced Mr. Garcia to take this job?
His wife, Katie.
Have you ever said that one of the reasons that Mr. Garcia participated in this murder for hire was that Katie McBanawa indicated that she would get back together with him if he did so?
Have I ever said that? I don't remember.
Do you remember giving a recorded statement to law enforcement on October 4th, 2016?
Yeah.
And during that time, as we indicated yesterday, you were accompanied by your attorney, correct?
Yes, sir.
As well as Detective Isom and Special Investigator Sanford, correct?
Yes, sir.
Give me a minute, sir. Can we come sidebar?
Okay.
May I continue, Judge?
You may.
Thank you. So it's your testimony today, sir, that you don't recall whether or not you
We're not
indicated...
going to repeat his testimony over and over again, Ms. Sangaday. Move on.
Will you agree with me that you believe that Ms. Bagbanawa was a driving force in convincing Mr. Garcia to commit this murder? That's
Yes, sir.
your testimony,
Yes,
correct?
sir.
It was also your testimony yesterday that immediately after the purported, after you committed the murder, that Mr. Garcia called Ms. Bagbanawa, correct?
That he called her?
Well, that's the first call he made after the murder, right?
That was the first call.
Okay. And you actually testified that while he was sitting next to you in the Prius, you could hear the conversation, correct?
Yes, sir.
Okay. And during that conversation, I believe your testimony was something to the effect is, it's done, right?
Yes, sir.
All right. And then it was followed up with, we're getting our money the next day, correct?
Yes, sir.
Nothing about, he didn't say anything to the effect of, you didn't hear, I did it, we're gonna be back together now, right?
No, not at
No.
all.
He didn't tell Katie, listen, I did what you asked me to do, I want to be back together with you, correct?
Not at all. So he hung up the phone and that's it.
Right. And the only contents of the conversation was with regards to money, right?
Yes, sir.
And you'll agree with me that prior to that, you indicated the driving force behind this was him getting back together with Katie, right?
Repeat that question again?
Sure, no problem. I just asked you, wasn't she extremely influential in having him do this, correct?
Yes, sir.
You also, and you'll agree with me that you believe that Ms. McManawa was extremely influential in decisions with regards to Mr. Garcia, correct?
Yes, sir.
My client was crazy about Ms. McManawa, correct?
Yeah. Yes, sir.
In love with her.
He still is.
You'll also agree with me that at the time of this situation, Ms. McManawa wasn't dating my client.
No, not at all.
She was
They were
dating
They were on and off.
on and off. But at the time that this took place, who was she dating?
The dentist.
You keep calling him the dentist. You know his name though, right?
Yeah, I just found out, Charlie.
Charlie. Now, there was a time where you were with Mr. Garcia and you went to a restaurant in Brickell, right?
Yes, sir.
And it was at this time where you saw Ms. McManawa with Dr. Adelson, correct? Charlie Adelson, the
Yes, sir.
dentist.
Yes, sir.
Have you ever testified that you'd never seen Charlie Adelson?
I ain't never seen him a day in my life. That day we went to the restaurant, I seen Katie. I don't know who he was.
As someone that, well, let me ask you this question. As someone that is a participant, someone that deals drugs, you don't deal drugs on the corner, correct?
No.
You deal drugs to people that you know, right?
Objection, Your Honor.
Sustained.
Did you know Katie McManawa?
Yes, sir.
Were you aware that Mr. Garcia was unhappy with the fact that she was dating Charlie Adelson?
Of course he was.
Would you say that Mr. Garcia liked Dr. Adelson?
Like him?
Right.
No.
Would you say that would probably be the opposite, that he disliked him?
Yeah, he disliked that man.
He disliked that man.
Yeah, just like he didn't like that man.
Right. He didn't like him. He was angry with him, right?
Yes, sir. Anybody with having a relationship, right?
Correct, but I'm talking about Mr. Garcia.
Yes, sir.
Would it be fair to say that he was unhappy with her relationship with the dentist, correct?
Yes, sir.
With Dr. Adelson, correct? Charlie
Yes, sir.
Adelson, right?
Yes, sir.
Would it be fair to say that you'd be able to see the anger in his face, correct?
Of course.
You would see that he would be sad, correct?
Yes, sir.
Yet it's your testimony that Mr. Garcia agreed to do an act that the Adelsons wanted, right?
Yes, sir.
Judge, can I get a minute?
No.
It's your testimony that you'd never seen Charlie Adelson, correct?
Yes, sir.
So you would deny selling drugs to Charlie Adelson?
Objection.
Sustained.
Did you ever sell drugs to Charlie Adelson?
Sustained. The
Objection.
objection is sustained by that.
Can we approach sidebar,
No.
Judge?
Move on.
Have third parties ever elicited you to purchase narcotics for other people?
Objection.
Sustained.
You're aware that Mr. Garcia was involved in a motorcycle accident, correct?
Yes, sir.
You're also aware that he received a settlement as a result of this motorcycle accident, correct?
A settlement?
A settlement, he got paid.
No, I don't remember that.
You don't remember that? Are you aware, or you indicated that you would have almost daily contact with Mr. Garcia, correct?
Yes, sir.
You'll agree with me that one of the things that he did to make money would be to buy and sell cars, correct?
Yes, sir.
Do you remember how many cars he's bought and sold?
No, not at all.
Would it be more than one?
Yeah.
More than 5?
Shit, I don't remember.
The government showed you a picture of a 1980, not 86? Monte Carlo, a purple one, correct?
Yes, sir.
How much did he pay for that car? Do you remember?
I think no more than $3,000.
So around $3,000. And how much did he pay for that motorcycle?
Like 38, $4,000 around there.
You don't remember?
Like 38 or $4,000 between.
And it's your testimony that he gave you $37,000 out of 100?
Yes, sir.
Did you deposit any of that money in the bank?
Nope.
Did you declare any of that money on your taxes?
Nope.
Do you know how the money was given to you?
Cash.
Cash?
Yes, sir.
$100 bills, right?
Yes, sir.
Stapled together?
Yes, sir.
And it was your testimony that the day after the murder that my client and Ms. McManawa were at Jessica's house, correct?
Yes, sir.
Did Jessica know about the murder?
No, sir, not at all.
So they did the money drop off at her house, right?
Yes, sir.
So in essence, at that point, you agree with me, Jessica now knew what was going on.
Not at all.
You just showed up and you got, would you normally get large amounts of cash like that?
No, sir.
How much would you make when you would do one of your jacks?
It depends.
10, 15, 20,000?
Yes, sir.
You don't consider that to be a large amount of cash?
Yes.
What's the most money you've ever made doing a robbery?
I don't know.
Well, let me ask you this. Is this the most amount of money you've ever made? And what?
Objection, Your Honor.
I overruled objection to that question.
Is this the most amount of money you've ever made in one setting?
No, sir.
No, sir? Okay. So this is not something that Jessica wrote. This is your wife, right? Your living girlfriend, your baby mama?
Yes, sir.
Okay. So did she ever ask you where you got this money?
She never asked me nothing.
And that's because she knows that you have a code of silence, right?
Yes, sir.
Yet you exposed her, according to your testimony, to this cash exchange. Was that normal?
Repeat that again?
Sure. You exposed her to this money exchange, right?
What do you mean by exposure?
She was there,
She was there.
right?
She never seen the money, though.
So they gave you a paper bag?
Yes, sir.
Okay. And she didn't see you taking, the $100 bills were stapled together, correct?
Yes, sir.
Okay. So did she see you taking the staples out of every?
No, sir.
No.
Not
You went
at
to a
all.
separate room?
Nope, I let them in my car. Grabbed the money and left.
Did you give any of this money to Jessica Rodriguez?
I gave her a few dollars, but she didn't know where it come from. She didn't, nothing.
Obviously, you don't want to get Jessica in trouble, right?
She don't know nothing. Why would I get in trouble?
I'm just asking in general. You wouldn't want her to get in trouble, correct?
I never tell her nothing.
Did Jessica? Okay, so you took a plea in this case to 19 years, correct?
Yes, sir.
But you're not going to serve 19 years in Florida State Prison, right?
Maybe, maybe not.
Well, your plea, the answer's not, because your plea was to 19 years to run at the same time as your 151-month sentence in federal court, correct?
Yes, sir.
Okay, so let's do the math here. 19 times 12 is 228. Minus 151 is 77. Divided by 12 is 6.4 years. So you're going to spend less than 6.5 years in Florida State Prison, correct?
If I do all my time in the feds. If I don't, I got to do more time in the state.
Your plea agreement, what we're talking about, not whether or not you get additional time or less time, but what you've agreed with the government, that's what I'm talking about, okay?
Yes, sir. I'm just explaining.
Okay, well, I'm asking what your plea agreement is. Your plea agreement is what you agreed to with the government, correct?
Yes, sir. I said 19.
19. So as we agreed, did you sit down and go over your plea agreement with your attorney? You did that, correct?
Yes, sir.
Okay, and he read all the portions of the plea agreement to you, correct?
Yes, sir.
And you began plea negotiations with the government probably in September of 2016?
Yeah.
And you were arrested or you were charged, because you were already in prison, right?
Yes, sir.
So you were charged in, was it May or June of 2016?
I think it was June.
It was June, right? Because you'll remember that law enforcement came to federal prison to talk to you in May of 2016, correct?
Yeah.
And when they first asked you about this, you'll agree with me that you denied any involvement, right?
Yes, sir.
Okay. And then from June to September, about 3 months, right?
Yeah.
You decided to become a cooperating witness with the state of Florida, correct?
Yes,
Okay. Did the government make you the 19-year offer before they spoke to you?
Did they make me?
Let me ask the question, sir. Did the government come and tell you, we're going to offer you 19 years, or did they sit down and talk to you and then make you that offer?
They didn't sit down and talk to me at all.
So at no point did you have any communication with the prosecutor?
At all.
That communication went through your attorney, correct?
Yes, sir.
Prior to the October 4th statement that you gave that's videotaped,
Yes, sir.
did you have communication with law enforcement that was not memorialized by video?
Say that again?
Sure. You've seen the video, right? The October 4th video?
I ain't really had no, I ain't see nothing. I was in a box. So I never got to see no videos or none of that.
Well, let me ask it this way. Was there ever a time, okay, prior to the recording, where law enforcement asked you questions that went through your attorney, okay, and he came and discussed those questions with you, and then you told your attorney the answers, and then he would go back and tell the police.
Yes, sir.
So your attorney acted as like a mediator, okay, between law enforcement and you, right?
Well, law enforcement would be with me in there, and I talk with my lawyer.
That's not what I asked you.
Well, you got me confused, man. Come back.
Okay. Law enforcement, was there a time where you were in separate rooms with law enforcement and you were alone with your attorney?
No, law enforcement, he was in the room.
Your attorney was in the room?
Yes, sir.
Okay. And then the police would come and talk to your attorney, and then he would come alone with you and have discussions, correct?
No, the cop was in the room as well.
Okay. Were you at the open table, or were you isolated and having a private conversation with your lawyer?
No, it was an open table. My lawyer, well, if I have a conversation with my lawyer, it's between me and my lawyer. But the detective was there.
Okay. Do you remember giving a deposition on January 31st, 2018? You remember me taking your deposition?
Oh, yeah.
Okay. And you remember when I asked you, where prior to the recording, law enforcement, page number, I apologize, 119 lines 11 to 15. Where I asked you, where prior to the recording, law enforcement asked questions that went through your attorney, and he came and discussed them with you, and then you told your attorney the answers, and he would go back and tell the police officers, and you answered, yes, sir. Do you recall that?
Yes, sir.
Objection, improper impeachment.
Overruled.
You remember that?
Yeah.
Okay. So what I asked you was, because what I asked you in that question, it appears that the answer is, well, strike that. Was this the same day as the recording? Do you remember?
What recording?
Okay. The October 4th recording. Do you recall if this is the same day?
Yeah.
And you'll agree with me that there are portions of your interaction, according to your own words, that were not memorialized on video, correct?
That it wasn't recorded?
Right.
I don't know if it was recorded or not.
Did they tell you at some point we're turning the camera on?
I believe every time I talk to any detective, it's getting recorded.
Now, between end of September and your statement, you took a ride down I-75 with the police, correct?
Yes, sir.
And during and the purpose of this was to see if you could retrieve the firearm that was used in this case, correct?
Yes, sir.
You'll agree with me that on that day, you spent multiple hours driving up and down I-75, correct?
Yes, sir.
How many miles would you say that you went from Tallahassee all the way south?
A lot of miles, I can say.
Did you get to Tampa?
Probably past Tampa.
Past Tampa. There's a real long bridge that you went over, correct?
Yeah.
Okay. Was that multiple hours?
Yeah.
Did they feed you?
Yeah.
You didn't eat prison food, right?
No.
They got you some McDonald's or something?
Yes.
And you actually had them stop at an underpass, which you believed was where the firearm was left, correct?
Yes, sir.
And law enforcement actually found a firearm there, didn't they?
I guess.
You guessed. I mean, they showed you. We found a gun, right?
No, nobody showed me nothing.
Didn't they? But you know that they found a firearm there, right?
I heard they found a gun.
Did they show you that gun to see if that you recognize the gun to be
No,
the gun in this
sir.
case?
No, sir.
Is that did you just take law enforcement to a known dumping ground for Latin kings to dump firearms?
Latin Kings.
You're a Latin king.
Why you keep saying Latin Kings? They ain't got nothing to do with this. You're wrong. You're wrong, man. This ain't got nothing to do with no Latin Kings.
So
It
you're
got to
not
do with me, Garcia. No Latin Kings.
So you're not answering my question. My
No.
Ask
question
him
was,
a straightforward question.
I said no.
Think of that.
I'm sorry?
Ask him another question. Ask him a straightforward question, not an argumentative one, please.
Give me just 1 second, Judge, I just received it back. Your Honor, may I approach?
Matt?
Mr. Rivera, I'm showing you what's been marked as Defense Exhibit B. You recognize that?
Yeah,
What is that?
that's a letter.
Who sent this letter?
I did.
And does that have your signature on it?
Yes, sir.
And who did you send this letter to?
Mr. Georgia?
Is this letter in the same condition that it was when you originally sent it?
Probably.
Does it look any different? Does it look altered in any way?
No.
Judge, at this time, the defense moves was previously marked as Defense Exhibit 3 into evidence.
Stay.
Just my general objection to them introducing evidence during my case in chief, Judge.
No specific objection.
No, Your Honor.
Let me see the exhibit.
Yes, Judge.
I'll admit, Garcia, Defense Exhibit 3.
Mr. Rivera, that says November 3rd, 2016, right? The numbers up there are consistent. That's the day you sent this letter?
Yes, sir.
And that letter's addressed to Ms. Kappelman, who's the state attorney in this case, this young lady right here.
Yes, sir.
This was a letter that you intended to send her, correct?
Yes, sir.
And whose signature is this down here?
That's mine.
And it says in this letter that since you've made a plea deal with the government and you told them everything they wanted to know, and you helped break the case, right? Correct?
Yes, sir.
That you've been in confinement 7 days a week, 3 hours a week to call your family, and that you want to go to general hospital, correct?
Yes, sir.
Because I have another exhibit, if I may approach Mr. Rivera.
You mind?
Mr. Rivera, do you recognize, I'm showing you what's been previously marked as Garcia's Exhibit 4. Do you recognize that document?
Yes, sir.
Is that a letter that you wrote to Ms. Kappelman?
Yes, sir.
Is that letter in the same or substantially the same condition as it was when you first sent it?
Yes, sir.
Is that your signature in the bottom right-hand corner?
Yes, sir.
Judge, at this time, I move what's previously been marked as Garcia's Exhibit 4 in evidence.
Any specific objection?
Yes, Your Honor. Hearsay and cumulative.
Let me see the letter.
Yes, Judge.
I'll overrule the objection and admit the letter.
Thank you, Judge. And Mr. Garcia, I'm sorry, Mr. Rivera, this letter went directly from you to Ms. Kaplan, correct?
Yes, sir.
You didn't send it to your attorney, correct?
No.
And in this letter, in essence, you want to get out of confinement, right?
Yes, sir.
And the reason why you said that you were in confinement was because you can help the government, correct?
Yes, sir.
Now, I'm showing you what's been marked as government, Defense Exhibit 4, or CF4. That's another letter you sent the same day, correct?
Yes, sir.
And you wrote, whose name is that?
Her name?
And what's her name?
Kaplan.
What's her first name?
Georgia.
Did you write this letter?
Somebody wrote it for me.
You wrote it.
I just rewrote it.
I'm sorry?
Somebody wrote the letter and I rewrote it.
So that's your actual handwriting?
Yeah.
And in this letter, what's the first sentence say?
Somebody wrote it for me, sir.
Right.
I can't read it.
You can't read it?
No, I had somebody write it for me. And he's the one that told me about it. And he wrote it for me. And I just rewrote it and sent it out.
Well, let me read it.
You don't need to read it, it's in evidence. Move on, Mr. Sangaday.
Well,
Move on. I said, move on.
Yes, sir.
We've done this, put the letter down.
You testified yesterday that as a result of your cooperation, your life would be in danger, correct?
Yes, sir.
That as a result of you cooperating with the government in this case, that they were going to kill you, right?
They're trying it right now.
I'm sorry?
They're trying to do it right now.
But you're here, right?
Talking to you, yes.
And those two letters that you sent Ms. Kappelman, you're asking to be put back in general population, correct?
Yes, sir.
Out of the SHU, out of protective custody.
Yes, sir.
Give me a second. Mr. Rivera, who wrote that letter for you?
That inmate.
You remember the inmate's name?
No, sir.
That inmate was in, I assume he was in the SHU in November of 2016? Do
Yes, sir.
you remember what pod you were in?
G-Pod.
G-pod, okay. On July 14th, 2014, you rented the Prius and came up to Tallahassee?
We're not gonna start repeating testimony, Mr.
I
Sangaday.
apologize.
Go to something new.
Where did you stay?
We've done that. Move on. Something new, Mr. Sangaday.
On the day in question, what time did you start following Mr. Markel?
This is something new, I said, Mr. Sangaday.
Do you remember what time you got to Premier Fitness?
Repeat that again?
Sure. Mr. Markel went to the gym, right?
Yes, sir.
Do you know what time you got to the gym?
No.
Were you following Mr. Markel from the daycare to the gym?
Yes, sir.
And it's your testimony that you were in the car with Mr. Garcia?
Yes, sir.
You weren't in the car with another Latin King?
No, sir, man. You bring this Latin King back and forth, man. You got my life in jeopardy right now just because, and yesterday you told me about the same thing. Where's my location at? My life is in jeopardy even worse now because now they know where I'm at. And that's protected custody.
So the answer to my question?
He answered your question. Do you have another question, Mr. Sangaday?
I do. How far behind Mr. Markel were you when he pulled into the gym?
To the gym,
Yeah. To Premier.
a few cars down from him.
So you were, let's say, 100 feet behind him?
Like two cars from me behind him.
2 cars? Would you say 5 seconds behind him?
Yeah.
and you pulled into the parking lot,
Yes, sir.
and you testify, well, at any point did you or Sigfredo Garcia get out of the Prius?
I ain't get off the Prius at all.
Did Mr. Garcia get out of, did Mr. Garcia get out of the Prius to urinate
Yes, sir.
in the Premier parking lot?
Yes, sir.
Where were you parked when you did that?
Almost towards the street, by a bush.
Was the parking lot empty or full?
I had cars around.
And by having cars around it, you mean there were a lot of cars around it?
Yes, sir.
And will you agree that there are people constantly coming in and out of the gymnasium?
Yes, sir.
And did you see someone who worked as, I don't know if they're security, but there was personnel or someone that was working on staff walking around the parking lot?
I don't remember.
Was it your plan that morning to commit the murder?
My plan?
Yes.
No.
Was this another surveillance day?
For the murder? The day of the murder?
What
That's
we're
another
talking
day.
about. I'm sorry?
It's another day.
Was it your plan when you woke up in the morning that that was the day you were going to commit the murder?
No, it was not my plan. We woke up and went do what we gotta do.
You had not called or you had not heard anybody call saying today we're going to commit the murder, correct?
No.
After Mr. Markel leaves the gym and you follow him, you pull out, when you see him pulling towards his neighborhood, you pull into another direction, correct?
Yes, sir.
Because you don't want him to be seeing you behind him, correct?
Yes, sir.
And you pull up into 2116 Trescott Ave, right behind his car that's in the garage,
Yes, sir.
and that's where Mr. Markel's killed.
Yes, sir.
And it's your testimony that you are not the shooter.
Yes, sir.
Is there anybody else that could testify to who the shooter is?
But that's not an appropriate question, Mr. Sanganet.
Was there anybody else in the car with you?
Garcia's in the car with me.
Anybody other than Garcia?
Nobody else.
So you'll agree that you're the only person that can
Let's
test.
go sidebar, please. I was hoping we could find a stopping point, but I guess we're gonna need to take a break. We'll let y'all step out, 15 minutes. Everybody be seated. Mr. Sanganet, do you wish to refresh the witness's recollection as to any issues?
Sure, I'm going to withdraw my last question.
Okay, but
I'll do that in front of the.
I've moved on to something different, I'm sorry. Do you wish, I said we'd give you an opportunity at the end of cross-examination to refresh his recollection if you desire, by reading to him what it is you wish to use to refresh. If we're gonna do that, let's do it now.
Let me take a look at my notes, Judge.
All right? It was turned down. Well, you get her to do it. It turned out there was user error. So. Okay. Right, I understand, but it's been working, so there's something you're doing that's making it not work, so, okay. But Johanna's the one that helped to fix it the other day. We lose Mr. Singh? Yeah. Where? Ms. Sangaday, do you wish to refresh recollection? Okay, well, let's wait to hear the answer to that. All right, and let me comment on something. There have been a couple of times when you obviously are soliciting information from Mr. Garcia in front of the jury. Don't do that, please. There have been a couple of times where there was something about what car it was or how much paid for the car. You're obviously looking over to Mr. Garcia and getting an affirmation of the correct answer. Don't do that in front of the jury, all right? That's inappropriate, okay? You understand what I'm talking about?
Yes, sir.
All right. All right, we'll take 10 minutes.